Good morning, everybody. This is Sam Abel-Palmer. I'm a staff attorney with the Disability Law Project at Vermont Legal Aid, and thank you for joining us this morning. Our topic this morning is officially titled Avoiding the School-to-Prison Pipeline, Children with Disabilities and Juvenile Justice in Vermont. And what I would really like to be able to do here is to spend some time to really go through both what leads kids into the juvenile justice system, especially the systematic kinds of things that get them there, and then also what happens once they're in the system, and in particular what families can do both preventatively to try to respond to situations that look like they're trending towards kids winding up in the system, and then also what happens if you do have a child who's in the system, what kinds of advocacy you can do, how you can work within the system to try to get the best outcome for your child. So if we can just get on to the next slide. And the first one is on the issue here. So the issue around the relationship between children with disabilities and the juvenile justice system, first of all, one of the things we certainly know is that children with disabilities have a disproportionately high representation within the juvenile justice system. This isn't just in Vermont. This is systematic throughout the country. We'll talk a little bit more about that level of prevalence in just a second, but we do know that this is the case, and in particular, children who have diagnoses in the emotional and behavioral areas, those are where we see the greatest prevalence. Sometimes, certainly there's also a lot of overlap with other kinds of diagnoses, learning disabilities, kids on the spectrum, but in particular, we see the disproportionality in kids with emotional and behavioral diagnoses. I think the central question when we're looking at addressing the problems of the system is looking at the difference between treating behaviors that the children are engaging in as criminal behaviors versus something that is coming as a result of their disabilities and something that we can look to treat and to modify. Looking at it, basically, are we looking at it in a punitive model or are we looking at it in a medical model? And how is the best way to, again, get to those better outcomes? How do we respond to kids who are in the system? What is a way to keep them from repeating, going back into the system to try to break the cycle of the behaviors that led to them being in the system in the first place? And then how do we support the system and try to change the system to provide the treatment that, again, that is going to get them out of the criminal justice system? So let's look at this question of prevalence. And the statistics here are extremely elusive. It's very difficult to pin down exact numbers. We're talking about, first of all, a large percentage of the children who are in the criminal justice system are kids who are really not necessarily on the grid. Kids who are falling between the cracks, whose attendance in school may be erratic, who are not necessarily, if they're on an IEP or a 504 plan, the school isn't necessarily following up very well in tracking how they're doing. So there have been a number of studies that have tried to pin down the question of how many kids within juvenile justice have some kind of either a diagnosis or are within the special education system, and every study that I've looked at that addresses this basically kind of says this is the best we can do, but we're assuming that the numbers that we have are not terribly accurate. The best information that I've been able to see recently, and this was done really kind of sideways a colleague of mine and I were doing a survey of special education services at the Woodside Juvenile Detention Facility, which is Vermont's lone detention facility, a locked facility in the juvenile justice system. And when we went to Woodside, we were able to get access to do a survey of all of the files of those kids confidentially. We had to maintain confidentiality, obviously, but we were able to get the basic information about those kids. And at Woodside, in that one snapshot that we saw, fully 90% of the students were either on an IEP or a 504 plan. And my sense for the other 10% was not that, it was more that maybe nobody was looking as opposed to whether they didn't qualify. And that was certainly a question that we raised with the folks at Woodside is, when somebody comes into the system who is not identified as being qualifying for special education, should you be doing an evaluation to see if they do, and are these kids who should be getting services who are not? My sense in looking at studies from other states is that Vermont probably does a better job than other places of identifying kids as needing special education services, that other states do not tend to report numbers as high as 90%, but that doesn't mean, again, that those are not the actual statistics. It may just mean that those kids are not being evaluated or identified appropriately. And so I think we do need to be looking at how many unidentified kids should be receiving supports. How do we identify the kids who are off the grid? People who have looked at this issue nationwide have devised this term called the school-to-prison pipeline. This is a term you'll see a lot being batted around lately, and I would actually encourage you, if you're interested in this topic, just take that term, school-to-prison pipeline, do a Google search and see what comes up. There'll be a lot of stuff. This is a topic of significant discussion lately all around the country. And a number of people in many states are looking at this question of, basically framing it as, not only are schools not necessarily, or the system in general not necessarily working to prevent kids from entering the juvenile justice system, that there are things within the system that actually encourage and essentially funnel kids with behavior problems into the juvenile justice system, that it's there's kind of a track that goes on, and that that there are systematic things, ways that we are doing discipline and response to behavior that that in many cases almost makes kids being in the juvenile justice system an inevitability. And I don't know of anybody who advocates for children who thinks that's a good thing, that we're looking to find ways to give alternatives to juvenile justice as a way of responding to kids with behavior issues. Again, here statistics are very elusive as to exactly how this works, but and again, as is kind of the knee-jerk reaction on a lot of these things, that Vermont, I think, probably is less bad than a lot of other places in the way that this works. I went to a conference, the statistic that I cite here on the slide, went to a conference for it's a group called the National Disability Rights Network, which is a national organization that looks at a lot of systemic issues around these kinds of questions, as well as many others. And there's a group working out of the Southern Poverty Law Center that's been doing a lot of litigation in the South around how school districts are responding to kids with behavior problems. And there was one case that they were taking that it was a large district in the state of Louisiana, where the statistic was that if you were a person of color and you were identified as somebody on special education services, that the graduation rate for those students was 7%. These kids were either dropping out or being expelled from school at just a mind-boggling rate, and then most of them just never finished school. They left. They were either in the criminal justice system or they just abandoned their education. And clearly that's a very deep-seated problem. There was another recent case, we was looking at it over the summer, a consent decree in a school in Mississippi where one of the terms of the consent decree was that the school was agreeing that they were no longer going to handcuff children with behavior problems to stair railings, which had been one of their regular practices. If they couldn't control a kid, they were literally handcuffing kids to the stairs and just leaving them there. Obviously this is not an effective way to address kids' behavior problems. I've not seen documented cases of quite that severity in Vermont, although we have had certainly some reports of kids being restrained inappropriately, of kids being secluded inappropriately when there are behavior problems. So, certainly we're not without our issues. And even when you have a situation where, kids are referred to juvenile justice, but you're saying, oh, we're just trying to let them know that this is an educational opportunity for kids, and we certainly hear that language sometimes, that we want to, let them know that this is the consequences of their action. I think you have to realize that's you're normalizing kids into the court system. It's their expectation, and it's the world that they learn to know, and they get used to it. And even though juvenile justice is in a different branch of the court system than the adult criminal justice system, they still get used to going to court, and and it does change mindsets. So it certainly is part of that pipeline process. There are a number of things that people have identified as being elements of the pipeline. How do kids wind up getting funneled into the system? And I've just listed some of the major issues that usually come up in these discussions. And I want to talk about each of these in turn and what may be appropriate responses, especially for families, if you see these things going on. And I think this gets us into, what are the preventative things that you can be doing? What are the ways that you can advocate systemically with schools to try to derail the pipeline, as it were. And so the 5 points that I've identified here are zero tolerance discipline policies, overuse of suspensions and expulsions, presence of police in schools, failure to identify students with disabilities, and failure to provide appropriate services. On the issue of zero tolerance policies, this is something, Janice and I were talking about this a little bit beforehand. It seems to be one of the real responses to the Columbine incident, and that, as well as just a lot of other incidents and increasing concerns about kids bringing weapons to schools and other behaviors. And so one of the ways that school districts across the country have developed to respond to this is to implement what they call zero tolerance policies. That if you are caught in a particular type of infraction, particularly bringing a weapon to school, bringing drugs to school, any certain levels of aggressive behavior, the school district will simply say, we're not going to give you a second chance. If you are found to have been guilty of this infraction one time, you're either on a mandatory suspension or a mandatory expulsion, and there's just no leeway within the school's written policies to have a more nuanced response to what maybe is causing this particular kind of behavior. The result of this is that you get a lot more kids out of school, because the response in zero tolerance tends to be either suspension or expulsion. You're removing the kids from the environment. In In certain cases, schools, especially if a student is on an IEP, there is a requirement to provide some level of tutoring services, but if the child has not been identified as special education, and in some cases, even if they are, schools are not providing those services, the kids are just out of school. And I worked with a family recently where their daughter was out of school with no services for a year. And, big surprise, she got in trouble and was cited into court. Even, when you leave a student without any school supervision, I mean, the parents, obviously are going to do their best to provide some level of structure, but parents work there. They don't have those resources. And when a kid is out of school, it's an almost inevitable consequence that they're going to wind up doing things that they probably shouldn't be doing, and the likelihood of an encounter with the juvenile justice system gets very high when you get kids out of school. So, I think, there's no, in most cases, except in a couple of very limited, even the federal laws that talk about zero tolerance do give schools some discretion. There's no requirement that a school have an absolute zero tolerance policy, and I think there is certainly, if your school district is responding that way and has that kind of a policy in place, I think there certainly are advocacy opportunities to say, look, is it the best idea to be pulling kids out of school? Is that going to be promoting their interest and the school's interest in the long run? It's an immediate response. It makes the problem go away, but is that the best way, both for the school itself and for the community as a whole, to be addressing this particular, a particular problem? If a child is out of school, there's often very little for them to go to. In this particular case that I saw recently, where the student was out of school, the parents were looking to enroll the student in a particular program, but that program wouldn't look at the student without a referral from the school, and the school's response was, "You're expelled. You're not a student here. We can't give you a referral." And so that community option wasn't available because the school said, "You're not a student here." And even in the best of circumstances, the options are often very limited. There aren't a lot of other things that teenagers can do other than being in school. And as soon as you get into the more rural areas of Vermont, those options are almost non-existent. It's very, very hard to find appropriate things for a student to be doing when they're not in school. And the other thing is to make sure that all kids who are eligible for special education or 504 services are identified, because, as I'll get to in just a minute, those do provide some protection from zero tolerance policies. Related to zero tolerance is the overuse of protection, of suspensions. Make it back to the previous slide there. This is clearly parallel to zero tolerance, but even when there isn't a zero tolerance policy in place, again, the standard response to any kind of serious behavior problem is to suspend the student, get them out of school, whether that's for a day or 3 days or longer. That's the primary tool that most school administrators have when faced with a student who is engaged in some kind of a serious infraction. And that could be out-of-school suspension, or it can be, a lot of schools use in-school suspension, which is essentially keeping the student in the planning room or some other isolated space within the school, but without access to their regular educational supports. Again, the question becomes, is this the best response to addressing a student who is engaging in inappropriate behaviors? Because by suspending them, you are removing them from their educational environment, removing them from the supports that they would otherwise get. There are students who certainly would see suspension as a reward rather than a punishment. Good, I don't have to be in school. I don't like school. Get me out of here. And so it does not become a positive reinforcer for the student to stop engaging in that behavior. I think the theory all along on suspension is, well, we want to get the parents engaged. We want to make sure the parents are being responsible for helping to address this behavior problem, and if we force the student to go home, then the parents have to deal with it. Well, that may work sometimes, but it sure doesn't work a lot of the time, and all you get is a kid sitting by themselves at home or on the street doing whatever they feel like doing. So again, it's questionable whether this, especially for a student who is starting to get into a pattern of potentially criminal behavior, suspension does not necessarily seem to be something that's going to help steer them away from from engaging in more behavior of that type. Again, we want to look at what kinds of advocacy, looking for alternatives. What are the kinds of alternatives to suspension that a principal can use? You've got a principal who's got a very busy day-to-day life. They have to make decisions very quickly. What do we do with this kid? Suspension is the kind of their default response because they may not have other options, or other options are harder or take more work, take up their staff time. But I think we need to at least engage school administrators in that discussion about what those alternatives could be. We can also advocate for schools to engage. I've just put the acronym here, PBIS. That's Positive Behavior Intervention Systems. This is a school-wide program that many schools in Vermont are engaged in that just try to rethink the whole discipline process, that instead of, again, having a punitive model of punishing students for engaging in these behaviors, you provide more positive supports for those students, excuse me, to give them alternatives to those behaviors and try to steer them away from the behaviors that they're engaging in. We could be spending multiple webinars on PBIS. I just want to put it out there as one of the alternatives that is available. And if your school has not looked at PBIS as something as a resource for discipline issues, you certainly can advocate with your school district to engage in that process. Department of Education provides all kinds of materials and support for that being done. It's a big process, but it can be a very positive one. Related to zero tolerance and the overuse of suspension, for kids who are identified as special education eligible or eligible under a 504 plan, there are limits on how long a school can remove them from the regular school environment. And in general, the basic rule is that as soon as a student has been removed from their official educational placement for more than 10 days, then other protections kick in. A school can suspend a student for up to 10 days in the same way that they would any other student. But for students who are on a 504 or IDEA or who are being evaluated, who've been identified as somebody who potentially might qualify, once you hit that 10-day suspension, the school is required to make a determination in a meeting with the parents to determine whether the behavior is or is not, it's called a manifestation of the disability. Manifestation means, does the behavior come as a result of the disability? The vast majority of cases, it is. I've seen schools try to argue that it's not, but it's very hard to say in most cases that it's not. Just a reminder, make sure that IDEA is the Individuals with Disabilities Education Act. That's the broad legal term for special education. So if your student has, and the other term you'll see batted around here, if your student has an IEP, an educational program, that's through IDEA. So that 10-day rule is generally in place, and in most cases schools will have to reintegrate a student back into the regular environment after that 10-day period, unless, first of all, if they determine that the student, that the behavior was not arising out of the disability, then they can just suspend, expel at will. If the behavior involves drugs, weapons, or serious bodily injury to another person, school can remove the student for up to 45 school days, 9 weeks, but they do have to provide services during that time. But if the behavior involves use or sale of drugs at school, all bets are off for 504, not for IDEA. For IDEA, for special education, then you're in the 9-week period. But if the student only has a 504 plan, and there's evidence of sale or use of drugs at school, they can just expel the student entirely, and I have seen that happen. So, but there are some protections, and if your child does have an IEP or is on a 504 plan, and you're getting around to that 10-day period, you can start asking about this and start advocating to make sure that the school is following proper procedures. Another element of the pipeline is police in schools. Again, we could be spending a whole hour at least talking about this, and I want to just touch base on this briefly. But since Columbine, a lot more schools are asking for police to be in schools. They're often called school resource officers, SROs. And we're seeing a lot more referrals to police for in-school behavior, fighting disorderly conduct that the school in past decades would have just treated as a discipline problem, internal discipline. There are no rules or regulations about how police operate in schools. Some kids, some schools just hire a security person who has no technical police training whatsoever. Others, the police officer is as an actual police officer with the local town or city department who is assigned to the school. There's no consistency at all. There are, and just had a question that came in about whether police in schools have to follow Vermont's restraint and seclusion rules. Just recently, schools have now, for the first time ever in Vermont, have to follow school districts have to follow regulations around when they can use restraint and seclusion of students. Those were initially applied to police. The legislature last year passed a law exempting the police from those regulations. Police are not subject to restraint and seclusion policies. Police can handcuff a kid, do whatever they deem is appropriate to do under regular police regulations, but nothing that is related to what the school has to do. They are independent folks. Now, if it's not an actual sworn officer, then that's not as clear a question. As I say, in spite of good intentions, having police in school inevitably increases the number of kids who are referred into the juvenile justice system. They're there, they're going to do their work. And so, again, there's a question that came in about whether police officers are allowed to question students under 18 at the school without parent permission. I don't want to say absolutely. I don't have a firm. I'd have to look at the statutory stuff right now before that. My sense is that, police have to follow police rules, and they have to do what they have to do. I think my sense is that police can be present if a school official is talking to a student, and students certainly, schools certainly can question a student at least on an initial run before they have to notify parents. They ultimately do have to notify the parents, but school administrators can at least talk to students initially. But that, I think, police can be present. But then again, police acting as police without the school, without the school administrators, police can simply operate as community police. And a good comment that just came in that parents should, if this is something that their kids are likely to be facing, parents you can talk to your kid about what to do if the police wants to talk to you and say, I want my parents here. And I think as soon as if the student says, I want my parents here, then there's going to be some obligation to call the parents in. I think there is some discretion, but that's even if a student is on an IEP. I mean, administrators can talk to students. That's the bottom line, is that the school has the leeway to ask questions of students in general. And again, police are not obligated by special education or 504 laws. Police are controlled by police laws, and so that's those are issues that definitely come up. Things to do, again, I think you can work with your local school district around policies and procedures for having police in schools. If the police are going to be there, there should be some set guidelines about what their role is, how they should be interacting with students. Clarify and define the role of police in schools. When I was at a meeting recently with the school resource officer in Montpelier, Montpelier has a very long and detailed memorandum of understanding between the school district and the police department as to who the police officer, what the role of the police officer is in the school, when it's appropriate for them to engage in an action, when it's not. It's a multi-page document, and in general, I think it's a pretty good outline that says the police are there to support, to educate. They are not there to take the place of the school's responsibility for conducting discipline. That the police are only supposed to respond as police in an actual criminal situation. All of that is laid out in this memorandum of understanding, and I think most schools don't have that, but I think it's a very good thing to have. So if your school doesn't have one, ask about it. And if your school is only hiring a security officer who is not trained as police, I think that in many ways may be a less controlled situation, because those folks are not trained or under the same regulations that police are. Advocate for training and communication between schools and police. You just throw somebody in there in the school district without any training, what's going to happen? Things are going to blow up. Police need training in what students' disabilities are like, what kind of behaviors get manifested, what's the difference between a kid with an emotional disturbance and a kid on the autism spectrum, and how they're going to react to a situation. All of those things are very important areas for training. And especially advocating with the school district not to just call in the police anytime a kid's engaged in a fight or in some other kind of behavior. We've seen kids with, just things that would normally just be a discipline referral to the principal, winding up cited into court on disorderly conduct because they got into a fight with another kid, and sometimes very young kids with police referrals because of doing something that happens in schools every day. And that's, I think that's to be avoided if possible, and that's something that you really need to advocate with the school administrators, because it's, if the police are there, it's the easy response to call them over and say, oh, we got a fight, officer, go take care of that, when it's really something the school could easily be handling. And the last two things that I just want to mention quickly, make sure we have time for some of the other stuff about the pipeline, about the juvenile justice system itself, is the failure to identify students with disabilities and the failure to provide services. Some school districts are great at doing this, others really drop the ball. But it is critical that if you have a student with a disability that involves behaviors that might get them into the criminal justice system, that you identify the disability, because that's going to be your primary tool in looking at alternatives to the criminal justice system. If you do not identify their disability, then they're just going to be labeled a bad kid, and then they're just going to be funneled through the system. I've certainly have seen a lot of parents who say, I don't want my kid labeled. I don't want my kid tagged with that disability definition. But without the without the label, you don't get the services, and you can't make I as a lawyer can't make an argument to the court. Look, this isn't a bad kid. This is a kid with a disability who is in need of treatment and services, not somebody who needs to be put on probation. So having effective, timely evaluations, current evaluations that are sensitive to the whole range of what's going on, is really very critical. And so we want to make sure we advocate with schools to make sure they're doing the evaluations, even, especially when some of these kids, the behaviors don't get to a clinical level till they're teenagers. And then those are kids who might not be identified as being eligible under special education or 504 because they weren't identified early on, and later on they're just kind of, floating through the system or not, starting not to show up to school. So having those identifications really are critical. And the last is the failure to provide services. Even if you identify the disability, if the kids are not getting the supports and services in school, that's a problem. One of the reasons a kid may be acting out is to get out of school because it's really too awful for them to be sitting in a room where they're expected to be able to read and they can't read. It's very common to see students responding to their feeling inadequate educationally by acting out, engaging in behaviors that get them out of that bad situation. And that's often, happens because they're not getting the appropriate supports and services either early on or at that particular time. So a lot of school districts just may not have the resources and the staffing to do the kinds of broad behavioral supports that might be necessary for really complicated kids. Especially we see this in a lot of smaller school districts where it's just hard to get enough supports in place. Those are the kids that sometimes get just shuttled off to outside programs instead of being kept within the regular educational environment. So again, advocating locally and statewide to have adequate resources both in school and the communities. The designated mental health agencies often are putting kids on waiting lists because they don't have enough counseling services available for kids who really need them in the community. Making sure if a student is engaging in problematic behaviors, ask the school to conduct a functional behavioral assessment to determine what's the cause of the behavior. Why is this kid acting out? What can we be doing differently to prevent the acting out behavior rather than just reinforcing it? You can invoke what's called the Act 264 process. Act 264 is also called the Coordinated Services process. This is the process where the school is required to sit down with the community agencies to say, why is this kid falling through the cracks? Why are these problems happening? What other services do we need to get into place to support the student to be able to function in the community, in the school environment, without engaging in antisocial behaviors? And again, advocating for positive behavior intervention systems is also another advocacy strategy. All right, so those, I think, quickly are things that are, ways that we can look preventatively. Kids get in the system. And so once a student is within the juvenile justice system, how can we support those students? What kind of advocacy can we be doing to help a kid get through the system and to avoid recycling back into the system, avoid recidivism of repeated referrals to juvenile justice? I want to do just a very quick overview of the juvenile justice process. It starts with either a police citation. Police can essentially offer, can give a kid a ticket with the citation into court, or if it's a more serious infraction, filing a petition, which is the the equivalent of an adult information, which is what gets you into the system. It's a referral to the state's attorney to say, this, police have to have a sworn statement that I observed this behavior, this is what happened, and refer to the state's attorney to begin that process. The student who receives that citation is appointed, usually both legal representation and a guardian ad litem. And then there's a preliminary hearing in the family division of the court. Juvenile justice is done in the family division, which is as opposed to the criminal division, and family division is a confidential process. It is the closed hearing, so it is a very different kind of system. However, it is possible, if the infraction is serious enough, for the children to be referred into the criminal division, and that certainly can and does happen. So there has to be a preliminary hearing where the judge is just getting everybody together. It's the equivalent of an arraignment. There's a pretrial hearing to see if there's going to be a plea deal, or if there's going to be an admission by the student to the delinquent behavior. Then there's if it's contested, then there's a merits hearing. Merits hearing is the family court equivalent of a trial, and is run pretty much the same way as a criminal trial is run. But instead of a conviction for a crime, it's an adjudication as a delinquent. That's what the family division is allowed to do. If there is, either by admission, by essentially a confession to the behavior, or an adjudication of delinquency after a merits hearing, the case is referred to the Department for Children and Families, who have usually been brought in well before this. They are, as soon as there is a referral from the state's attorney, DCF is going to be brought in. But if there is an adjudication, then DCF is responsible for developing a disposition case plan. They have to come up, well, what are we going to do for this kid now that we have this delinquency adjudication? The disposition hearing reviews DCF's proposed case plan, and then the judge will enter a disposition order, which is usually going to rubber stamp what DCF recommends, but that can include probation, it can include detention, change in custody, treatment that's ordered, restitution. All of those things are possible under the disposition order. And that then becomes, the kid has to follow it. If they don't follow it, you get cited back into court for failure to follow the disposition plan. Another option, and I didn't list this here and really should have, is one of the things that the judge can order as part of a disposition order, is to go into a restorative justice system, the community justice organizations that exist, where instead of being, say, on probation, the kid can be brought in, get counseling, work through what happened, and look for ways for, which also often involves restitution to the victims, but can also involve other kinds of more kind of out-of-the-box creative planning. What is the kid going to do not to have this happen again? Those are available. I believe there are 12 community justice centers around the state. 3 or 4 of them are here in Chittenden County, but there's most of the major cities around the state have them, but not all. And the rural areas generally do not have them. So availability of community justice as an option for judges is erratic. When it's available, it can be a really great positive process, but it is not always available, and I think judges will often avail themselves of it. And with somebody else pointed out, also court diversion. Again, there are ways to, if you kind of get together with the state's attorney early on in the process, say, what can we be doing? And there are ways to kind of sidestep the court process, again, by invoking the community justice process or some other restorative or reparative means, there are ways out of the regular track. But that involves advocacy. It involves talking to the state's attorneys. They're going to want to know that there are people in place, there's a support system in place for these kids who are going to help to shepherd them through these alternatives. And if DCF doesn't think that those services are available, they're going to send a kid into the regular system, because they're not going to want to let go unless they're confident that somebody's going to be there to make sure these other things happen. The juvenile justice system is governed by family court rules. Court rules don't talk about disability very much. The only place that they specifically talk about evaluation for disability is in whether a child is going to be deemed incompetent to stand trial. And just as you may be found to be not competent to stand trial for a criminal matter, a child can be found not competent to stand for a merits hearing in a juvenile justice proceeding. And in that case, the court will usually order an evaluation, and it's done essentially by the same standards, a little more leeway. But that's something that, that's the only time that the court rules really specifically address it. Court has the option to order an evaluation for around disability or mental status at any time, but often that's discretionary to the judge and whether or not the child's attorney is asking for it. What the rules much more often talk about the child's emotional maturity, but really what you're talking about there is what their diagnosis is and where they fall within that diagnostic profile. So courts can and should be factoring disability into proceedings. It doesn't always happen, but it certainly should be. You have a group of public defenders who are incredibly busy. They're overloaded. They're cranking kids through the system, and they don't always have the time or the resources to be asking for these evaluations. And so I think one of the things families can do is to be advocating with the defenders. Ask for the evaluation, talk to the DCF workers, get the appropriate evaluations, get a treatment plan in place, make sure the judge is aware of those recommendations. If a recent evaluation recommends a certain course of treatment, you might get the judge to order it, and then that's going to be much more likely to be happening than if the judge is trying to kind of make this up on the fly. So if those resources are available, you should be advocating for them to get those in place. Identifying appropriate services based on diagnosis. Requesting updates for evaluations. Advocating for the school to start engaging in the process to help with the evaluation process. Often, once a kid is in the juvenile justice system, the school's kind of going, not our problem anymore, and there's no requirement that the school engage in the process, but often the schools can give tremendously valuable information to the court and to DCF about what the student's real needs are. And if those are not identified, again, they're not going to wind up in that disposition order. And you want to make sure that those things are getting into the disposition order. We had a case we worked on recently where a student had been conditionally removed from his mother's custody. We were in the court. DCF had placed him in a very restrictive behavior program. Mother had been advocating all along and saying, look, this is a kid who's probably on the spectrum. He hasn't officially been diagnosed yet, but we think this is what's going on. He's going to get eaten alive in this program where you're placing him. And we were able to get enough information to the judge that he basically was able to revise both custody and the disposition plan just to get the kid out of that particular placement. Judges are not allowed to make placements. The only DCF makes out-of-home placements. Judges can only tell DCF, can't, other than Woodside for detention, The judge is not going to tell DCF where to put a kid, but the judge can certainly lean on DCF to make a more appropriate placement, and in this particular case, we did see that happening. As I said, if a child is adjudicated delinquent, the DCF's role is to create the disposition plan and to implement it, so they're very heavily involved, likely to be involved earlier. They're going to start if a child is in the system, they're going to be looking at custody issues. There may be concurrent termination of parental rights, or at least CHINs, child in need of services, proceedings that might have a child removed from the parent's custody if DCF feels that that's going to be the appropriate course of action. These things can escalate very fast and involve a lot of very problematic, high-tension kinds of adversarial proceedings, especially if DCF sees a kid who's getting multiple delinquency referrals. They're going to start cranking up the proceedings around custody and placement of a kid, and likely try to get a kid into custody, into a foster placement, if they see this happening on multiple occasions. And as I note here, once DCF is involved, parents are going to start to feel out of control. They're not going to have as much say in placement. This is where advocacy strategies become even more vital, because again, we've got it's kind of a juggernaut once the system gets going, and you have to talk long and loud and pool your resources and your advocates, bring them to the table, get the community agencies to the table, get the school to the table, anybody who's going to be supportive, to say, what does this child need, how are we going to get it in place, and what's the best place for that to happen. The disposition plans, the court has to create this plan if you have a delinquency adjudication. But again, it's really vital to make sure that the DCF is putting diagnosis and treatment options into that plan, making sure they're aware of it, that they have the updated evaluations. If they have a good evaluation, odds are the social worker is going to work those recommendations into a plan, because it makes their job easier if they've got a good evaluation. It means they can just copy it in there, and they're overworked too. Placement should be sensitive to diagnosis. I've seen kids, who as soon as they get into the DCF says, oh, this kid is escalating behavior, we have to get them out of the home and into a foster placement, and as soon as they get into the foster placement, the behaviors escalate even more because the kid wants to go home. The kid doesn't want to be in the foster placement, and so it just makes the situation worse. I've seen that happen a couple of times. So the placement has to be sensitive to what this kid needs and how this kid is going to react. Making sure DCF has full information, making sure the court has full information. And if the plan is wrong, it can be contested in a hearing. And that is available there has to be a hearing on the disposition plan itself even after an adjudication, so that can be contested. Wanted to just make sure there's just a little information about Woodside. I've mentioned Woodside a couple of times. Woodside is Vermont's only juvenile detention facility. It's a pretty small place, about beds for about 30 kids. So again, compared to other states, it's not as bad. It's not, my initial reaction the first time I visited there was that I was expecting it to be a lot more awful than it was, which I guess is, it's damning with faint praise. But, when you hear the horror stories of juvenile detention facilities in other states, which really are just jails, and I think Woodside has worked to get better. I think there were some real problems there a number of years ago. I think it is better than it used to be. Woodside is available both for short and long-term placement. Short-term can be as quick as a single night. It can be as long as several years. So it just depends on it. But ultimately, the judge has to order placement in the detention facility. There is work at Woodside to really shift it from being a detention facility to being a treatment facility. but it still does function as the one detention facility that we have in the state. We've certainly worked with folks in my office have worked with and we had folks at Disability Rights Vermont as well, working with Woodside closely to improve the educational and therapeutic services, and they have made some real strides there. Because it is only 30 beds, DCF can't just throw every kid into Woodside. There just isn't space. So they do rely on other placements. They wind up sending a lot of kids to the retreat because that's what's available, or into foster care placements. And if it's a long-term situation, to out-of-state facilities, because we just don't have facilities in Vermont to deal with kids with significant behavior issues. So, but on a short-term basis, if a kid is engaging in some very dangerous behavior and is not able to be de-escalated in the short term, odds are they're going to wind up in Woodside for at least a short time. Ultimately, and kind of in closing here, we want to try to avoid the system. And I think the main strategies are holding schools accountable to making sure that the kids are getting the services in place in the first place so that they're not engaging in the behaviors that are going to land them in the juvenile justice system. And that's both schools and community-based services, I think, as well. Advocating for school discipline and behavior policies that don't get kids out of schools, that keep kids in schools, keep kids getting services, not relying on suspension and expulsion. Making sure that the community-based agencies provide adequate behavioral and mental health services. Families are overwhelmed in these circumstances. This is tough. Kids run away. Kids are defiant. It's not easy. This is the kind of thing that puts families in the greatest possible stress. And you need the supports in the community because the schools can't do it all. And advocating for family supports to provide those services for the stressed families. The kids that we saw in Woodside, some of the kids in Woodside, when we did our review, were getting tremendous family support, but a lot of them were, the kids were because of those stresses, the families fell apart. And there just was no safety net for the kids. And that was clearly the image. Now, and again, some kids are just going to engage in these behaviors no matter what the families do, no matter how good the supports. But we saw case after case where it was the school dropping the ball, where the families were unsupported, where the kids were, just cycling in and out of school. The kids were bouncing from one school to another, one placement to another. Those were the kids that we saw in the system. So, we do have one question here, a little time here. So, question that came in the case of a physical altercation, either fighting or pushing, are teachers or administrators allowed to step in, which involves touching children, or is there only recourse to call a police officer? Yes, teachers are allowed to intervene. The new restraint and seclusion rules are actually very clear that there are only certain kinds of physical touching that constitute restraint and seclusion, and the teachers are, there is no policy, there is no rule statewide that says a teacher can't touch a student. Teachers may come into physical contact with students. They certainly may. And when students are at risk of immediate harm and safety, you can pull a kid back. Teachers are absolutely allowed to intervene in those situations without running afoul of the restraint and seclusion rules. Teachers can intervene in those situations. Teachers should be intervening in those situations to promote the safety of students, to stop fighting, not call the police in if they don't have to. Yes, teachers are absolutely allowed to do that. So I think I think a lot of teachers are petrified about touching students, but they are absolutely allowed to intervene in those situations and can often do a much better job of de-escalating. Another question, is there data to support the common belief that students can be scared straight by entering the criminal justice system? Not that I've seen. It certainly is something that people think is the case. I've never seen it. And I think, again, I think you're in just as great danger of just normalizing kids into the system rather than helping them to get out of it. Last question, are there any statewide organizations that are advocating for these kinds of changes? I think Vermont Family Network is probably the primary one. And, at Disability Law Project at Legal Aid and Disability Rights Vermont, we're certainly trying to work on things. I think the juvenile defender system, folks like Bob Scheel in the Defender General's office are very aware of these problems and are very interested in working on them as well. Actually, one more here. How are the overall numbers of youth in the juvenile justice system going up or down? I don't actually have those statistics. I haven't seen any recent numbers, so I don't know. There were certainly plenty of kids in and out of Woodside in the times that I've been looking at it. I haven't noticed any. I haven't noticed them looking for, saying, oh, we have all these empty beds. They're full up a good deal of the time. All right. Well, thank you to everybody for participating, and glad you're able to join us. And hope you're able to participate in another one of the VFN webinars.